Are you having difficulty co-parenting with your child's mother or father? Are you disagreeing about what the best thing to do for your child is and reaching an impasse with no way to move forward to an end goal? Do you have concerns about your child's well-being and the other parent's care? And today's video is for those who find themselves facing the challenging process of seeking custody of their child. People often phrase their dilemma as simply wanting custody of their child or children, but often fail to distinguish what the specific issue they are facing is. Is the parent refusing to let your child attend therapy? Is there a disagreement about where the child should attend school? Do you not believe your child is safe in the other parent's home? Is the other parent neglecting to spend quality time with your child? It is important to know that there are two different types of custody that the court considers and makes decisions on. It is crucial to understand the two different types of custody before diving into the process so that you and your attorney can be crystal clear on what goal or goals you are trying to achieve, and so that you can together craft the best legal pathway to get you there. There is physical custody, also known as parenting time, which involves where the child will live, who they spend their time with, and when. There is also legal custody, also known as decision-making authority, which details how important decisions concerning major areas of your child's life, like where they go to school, what medical providers they see, what religion they practice, who these decisions are made by, and equally as important, how these decisions are made. Courts can award joint or sole custody depending on various factors unique to your situation. In Maryland, courts make custody decisions based on what is in the best interest of the child or children. Common factors used by the court in ascertaining what is in the best interest of the child include the child's age, the mental and physical health of each parent, the stability of their respective living situations, and the child's relationship with each parent. You should be prepared to demonstrate your commitment to providing a stable and loving environment. It is important to highlight your positive contributions to your children and how your continued or increased involvement is in their best interest. Here are 5 examples of things you can do to improve your chances of success. Number 1, make sure you are taking an active role in your child's life. Keep a record of your attendance at their school events, their medical, and any other activities concerning them. These kinds of records and documentation will strengthen your case. It is in your child's best interest to be the parent who knows and understands their wants and needs, and even more so, how to improve them or ensure that they remain at a high level. Number 2, have or obtain a stable and beneficial living environment. Ensuring that you have a home that suits your child's needs is critical. Do they have their own bedroom? Are they near friends or suitable activities? Do they have extended family members they can have a substantive relationship? How close are they to their school? It is important to demonstrate your ability to stabilize your child's life and provide security, especially if that's not the case for your co-parent. Number 3, develop and promote a good relationship with your co-parent. While it may be difficult at times, encouraging a positive relationship between your child and the other parent demonstrates a willingness to cooperate and put your feelings aside for the benefit of your child. At the very least, making an effort to avoid speaking negatively about the other parent in front of your child or putting your child in the middle of a parental dispute, avoid such behaviors being used against you in the future. Text messages of you calling the other party names or disclosing a conflict with your co-parent to your child can be damaging. Number 4, maintain a healthy lifestyle. It's important to demonstrate that you yourself are not only an attentive parent, but one who is healthy and responsible as well. Avoiding behaviors that can be detrimental to your child's well-being, such as excessive drinking, especially in their presence, substance use and abuse, reckless driving, emotional outbursts and anger, again, especially in their presence, help to limit the amount of harmful testimony or evidence that can be used against you in a custody proceeding. Number 5, be financially responsible. Ensure that you are contributing to and providing for your child's needs. Understanding your child's financial needs, such as health insurance, medical care, enrollment in extracurricular activities they like, and payment for daycare that is necessary while you and or your co-parent work, all demonstrate a sense of financial responsibility towards your child and an understanding of their needs and best interests. Avoid being typecast as the deadbeat parent. You should keep in mind that litigation is not the only way to achieve your custody goals. Many jurisdictions require the parties to attend mediation before going to court. At mediation, you and your co-parent will speak with a neutral third-party legal professional, often a family law attorney familiar with the area, or a retired judge, who will help you attempt to reach an agreement about what custody arrangement is in your child's best interest. It is important to remember to be open to negotiation and communication with the other parent. A willingness to cooperate and find common ground can positively impact the outcome, not only for you, but for your child. Mediation aims to find amicable solutions that work both for you, your co-parent, and your children. Gaining custody of your child is a complex process, but with careful preparation, documentation, and legal guidance, you can navigate it successfully. Remember, every case is unique, so consult with a legal professional like the ones here at Paré Associates for advice specific to your situation.